When I was a young lawyer, I had the privilege of practicing in the presence of some real characters. One of those was a defense attorney, a criminal defense attorney named Joe Lax. He was a deputy sheriff from Oklahoma. And in a motion, he once called the people's case thinner than piss on a hot rock. And I thought about that when I started investigating the case against Judge Hannah Dugan in Wisconsin, arrested for shepherding a allegedly undocumented immigrant out of her courtroom through a side door when ICE officers were in the hallway waiting to arrest him. If somebody were to invite me to represent either the United States in this controversy or Judge Dugan, I would choose Judge Dugan's side before they even finished the question. And the reason is because I've done some very quick research. The United States case is thin at best. The complaint filed by the United States Attorney's Office states what law they're charging Judge Dugan under. It's 18 United States Code, Section 1505. And in that complaint that the United States Attorney's Office filed, they also stated their rendition of the facts. And I'm going to assume that all of the facts that they stated are true. This is the analysis. I'm going to read from the criminal statute, and I'm just going to read the parts that apply to this case. Whoever corruptly influences, obstructs, or impedes, or endeavors to influence, obstruct, or impede the due and proper administration of law, under which any pending proceeding is being had before any department or agency of the United States, shall be fined under this title, imprisoned not more than 5 years, etc. That's the nub of the allegation, the law under which the United States is charging Judge Dugan. I expect that Judge Dugan's lawyers are going to concede that many of the elements of this offense have been established. It's pretty clear that Judge Dugan did help a defendant in her courtroom evade ICE seizure, and the case would be over except for one thing. Because there's one element of the case that seems to me is clearly missing. Now, what is that missing element? The law, that is, 18 U.S.C. 1505 requires that the person to be guilty has to act corruptly. Now, corruptly is defined in 18 U.S.C. 1515. And it says that corruptly means acting with an improper purpose. Now let's take a look at what an improper purpose means for purposes of this case. So what was the judge's motive? I'd lay money that it had nothing to do with some political resistance to the deportation regime of the present government, the present federal government. Judge Dugan is handling criminal cases. And there are two considerations here. One is, you can show up to any criminal arraignment court and see that there are a lot of people who just refuse to show up for their criminal cases. Certainly, if a defendant doesn't show up in court, a warrant is issued. But for a variety of reasons that I'm not going to get into right now, there's some substantial chance that that defendant will disappear off the court's radar forever. And that case will remain on the court's records unresolved forever and forever and forever. And the judge probably wants to encourage criminal defendants to show up. And they're not going to if they realize that the ICE may essentially be fishing in the hatchery, looking for the easy pickups. because that's going to discourage people from showing up. The consequences of being picked up by ICE may seem much more onerous to a criminal defendant than the criminal case itself. And I can see a judge in a criminal case defending her turf from that kind of invasion by another agency of another branch of government looking for easy pickings. But let's kick it up a notch. Because in any criminal case, or many criminal cases, there's more at stake than just the liberty of the defendant. In many cases, there's a complaining party. And in many of those cases, the complaining party is a legitimate victim, somebody who really does need justice, a person who may crave justice. It's easy to believe that in doing what she was doing, Judge Hannah Dugan believed that she was protecting a core function of the Superior Court in Milwaukee County. That core function is to bring cases to completion. That core function is endangered when an agency of the federal government like ICE decides to take the easy road of just arresting people when they show up to court in matters unrelated to any criminal case and indeed to any judicial warrant. Judge Dugan might have been right or she might have been wrong. That's not what I'm debating here. Nobody really knows what additional facts are going to come out in this case. I'm arguing based upon the state of the record as it is right now. But it's hard to believe that a jury is going to find her guilty, because in order to find her guilty, a jury's got to find that she acted corruptly, that is, with an improper purpose. They're going to have to find that in protecting the core function of Milwaukee County's Superior Court, Judge Dugan was acting corruptly, that it is corrupt for a judge to want to make sure that defendants appear in court either to eventually receive their punishment or to be vindicated. And a jury would have to find that it is an improper purpose, it is corrupt for a judge to care about victims of crimes getting closure. And I just don't see that happening.